If you are facing a domestic violence restraining order, then one of the key pieces of evidence that you probably have are text messages. And you might be wondering, well, how do I use these text messages? I mean, maybe you have hundreds of them, especially if the relationship spanned a few years. What do you do with them? Is the judge going to really read them? Will the judge let you read them? How long would that take? So in this video, I'm going to be talking about 5 different ways that you can use text messages in your domestic violence restraining order hearing to maximize their effectiveness. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I also teach a course called Defeat the DVRO, in which I teach people who want to defend themselves at their restraining order hearings and maximize their chances of winning exactly what to do. So make sure to click down below in the description box and get your free first class. Okay, so let's jump right in. 5 easy ways to use text messages in your domestic violence restraining order hearing. Number 1, establish a timeline. Text messages often have timestamps. They at least have date stamps. So you can use those to establish a timeline to either bolster your version of events, your story, or show that the petitioners, that the other parties are unlikely to be true. One example of this would be, Your Honor, as per these time-stamped text messages, you can see that the petitioner and I were having a normal conversation on the day of the alleged threats. These messages do not indicate any hostility or any threats at all. In that example, the petitioner said in her application for a restraining order that some sort of abuse happened on a particular day. So if you can show that, all day long, you and the petitioner were texting back and forth, she ends the day with saying, "I love you, sweetie, good night," something like that, then it makes it less likely that abuse occurred. Is it 100%? Is it airtight? No. But the thing is, with these restraining orders, nothing is really 100% or airtight. So what you need to do is just use whatever evidence you have to bolster your version of events and take hers down a notch. Number 2, show the nature of the relationship and your typical interactions. If the petitioner is saying that there's this relationship that was all about control and abuse, and this was a constant thing, but you can show that in text messages with her, or with him, you were cordial, you were respectful, then that is going to go a long way to showing that you aren't the abuser that he or she is trying to paint you to be. Example, these messages show that we had a cordial and mutually respectful relationship, which contradicts the petitioner's allegations of a pattern of intimidation and threat. So in this example, if the petitioner is saying that you were always intimidating her and threatening her, but you're sending her emojis and memes, it contradicts her characterization of their relationship. And one thing that's important to remember in these restraining order hearings is that the judge has to decide in a very short period of time who to side with. And the judge only has to side with one of you more than 50% and the other less than 50%. So if you have all these text messages already prepared, ready to go, ready to show the judge, and the petitioner just comes in with her text messages being a mess, not having them printed out, just having them on her phone, or maybe doesn't bring text messages at all, then that is going to weigh in your favor when the judge is deciding who is above 50% and who is below 50%. Number 3, prove location or actions. If the text messages discuss a particular event or a particular location, then you may be able to use that to show that the petitioner is not telling the truth. For example, in this text, sent at the time of the alleged incident, I mentioned being at a family gathering, which is corroborated by these photos, bring the photos in too, and by multiple witnesses. Basically, you're using the text message as your alibi. If you were at a family event or you were in a different city or a different country at the time that she's saying that you abused her, then you need to bring that in as your alibi. And again, it's not airtight, right? I mean, I guess you could have sent the text message saying I was at a family gathering, but you were actually at home abusing him or her and sending this text message talking about the family event. But that seems a little bit far-fetched. You didn't know that he or she was going to file this domestic violence restraining order on you. And again, you're just trying to tip the scales in your favor as much as you can. Number 4, reveal contradictions. If the petitioner's claims don't match the content or the tone of the text messages, then you can use that to cast doubt on the veracity, basically the truthfulness of her claims. For example, Your Honor, the petitioner alleges that they felt threatened by me on this date. However, in these text messages sent the very same day, they were discussing our weekend plans. This is inconsistent with their claims. Number 5, demonstrate attempts at resolution or de-escalation. If you have tried to de-escalate fights or arguments in the past and you have done that via text message, then that paints a picture of someone who is more of a peacemaker than an abuser. Of course, it's on a case-by-case basis. But if the petitioner is trying to say that you are this abusive person, you're a hothead, you have this bad temper, and in text messages you're saying, hey, please talk to me about this. Let's have a conversation. And that can help to show that your actions were not malicious or threatening, even if you did have an argument. For example, as you can see from these texts, I attempted to have a calm and peaceful conversation about our disagreements. At no point did I make any threats or show any sign of aggression. Again, it's not 100%, but you don't need 100% to win a restraining order hearing. If you've made it this far in the video, then you obviously really care about learning as much as you can to try to empower yourself to win your restraining order hearing. And I can teach you how to maximize your chances of winning. You can find your first free class on my course, Defeat the DVRO, via the link down below. You have nothing to lose, so you can keep scrolling on YouTube hoping to find the answers or get them handed to you, which is exactly what I do in the class. I hope you found this video helpful. If you did, please don't forget to subscribe, like, and ring the bell.